Sycamore Meadows versus Caleb P.
Jill Bauer on behalf of Ms. P, Your Honor, who's also present.
Attorney Carrie Zanon on behalf of plaintiff.
All right, it's your motion.
Your Honor, we entered into a consent order. I brought printouts if you would like to look at it. Ms. P, you can.
How in God's name was I ever going to forget it? But go ahead.
Well, Your Honor, it said that Ms. P would be rehoused by July 31st. And if there were delays beyond plaintiff's control, that plaintiff would immediately contact me and a reasonable extension would be agreed upon. I was out of town when I came back and found out that Ms. P was unhoused. I started trying to reach out on July 31st to find out when she was going to be moved.
Actually, Judge, I think it's earlier than July 31st.
Okay. And I'm not trying to throw Miss Zanon under the bus at all because she was very much communicative with me, but we weren't actually able to get any information about the move-in until August 8th. And we were told that Miss P would be moved in yesterday. So Miss P went yesterday to try to move in, and the first person she talked to didn't even know anything about it. And then someone else came out and they walked her through a unit that was not ready yet. So they told her to come back at 1 o'clock today, which she did. And she signed all the paperwork and everything. And then they told her to come back at 5 o'clock to get her keys. She didn't know what to do. She knew that we had court. She came here for court, but she still does not have keys. I don't know why they didn't give her the keys at 1 o'clock and just say, wait till 5 o'clock to enter the unit. But she still does not have keys. And when she left to come to court and she's using the bus, but she saw that there were 2 golf carts outside of the unit and it was still being worked on. So I just wanted to bring this before the court because they didn't follow the order. I mean, it was very simple to reach out proactively and say what this is going on. We need an extension, but instead she's been up in the air for weeks.
Can I respond?
Yes.
Judge, counsel's accurate. I did not have a move-in date until last week sometime. I was told that she'd be moved in on the 14th, which was yesterday. As to today's incidents, I actually talked to my client and I was on speakerphone, and Miss P was in the office while I was on the phone with her. They were going through the move-in process. They had actually gone through, walked through yesterday. There was an exposed outlet that my client didn't feel comfortable moving her in yesterday. They had a conversation. They also told her that they were going to put the appliances in today, which is why the keys weren't handed to her, because the maintenance was in there putting the appliances in today. So my understanding was that they were going to do all of the paperwork today, and she was going to be able to move in once the appliances were completed, and they were doing that while she was in the office. So she knew that that's what was going on because she agreed that they could put the appliances in today. The keys have been cut. They're at the office. To speak to the time frame, Judge, I have 2 maintenance men that work there. That's it. And the complex is huge. And I have 1 on-site manager. When I spoke with the manager, and I just wanted the court to know that at 1:30, when they were doing the move-in process, I didn't want my client to up and leave and not complete it to be here. So I'm asking that the keys are ready to go.
Anything else?
Your Honor, I would ask at a minimum that they bring the keys to Miss P here at the courthouse so that she has access.
That's not happening. Is there somebody at the office? Do we know?
Yes, but Judge, I will call if you want to pass, give me a minute. I'll call right now and make sure that where the key is going to be so that we know before we leave.
Quarter past a minute.
I just want to make a record. You're going to have to take the bus back to Sycamore.
We hear that, but maybe the decision that should have been made is she could have done something via Zoom, something else, so that she's there to pick up the keys if the keys were going to be ready at 5. These are problems that are being created that don't have to be. I mean, it would be nice if everybody's life operated as if legal services wanted it to on some great strict timeline, but nobody's life operates that way. So find out where the keys
I
are.
will.
I'll recall the case.
Thank you, Judge.
This is actually one of the most important moments in the hearing, because the dispute has shifted away from simply asking whether the landlord missed a deadline. The court is now focused on solving the tenant's immediate housing problem, while also evaluating whether either side acted reasonably under the existing court order. Notice that Judge Simpson doesn't immediately punish the landlord, even after hearing that the agreed move-in date was missed. Instead, he starts looking at whether the delay resulted from intentional non-compliance, or from practical issues like unfinished repairs and staffing limitations. That distinction matters legally, because sanctions are generally reserved for situations where a party willfully ignores a court order, not when circumstances become more complicated than anticipated. At the same time, the judge doesn't completely excuse what happened. He points out that better communication could have prevented much of this confusion. That's an important lesson in landlord-tenant litigation. Courts expect parties not only to comply with orders but also to communicate promptly when compliance becomes difficult. A missed deadline accompanied by proactive communication is often viewed very differently from a missed deadline followed by silence. There's another subtle point many viewers may overlook. Rather than allowing both attorneys to continue arguing over who bears the greater blame, Judge Simpson redirects everyone toward a practical solution: getting the tenant access to the unit as quickly as possible. Judges frequently prioritize resolving the real-world problem before deciding whether additional legal remedies are necessary. That approach often reduces further harm while preserving the court's ability to address disputes later if needed.
Forsno versus Tequila Smith.
Thank you, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff.
All right.
Trying
Your
to-
name?
Tequila Smith.
All right. And
Honor.
where are we on this case?
Yeah, thank you. Jill Bauer has been assisting Tequila Smith. You'll see on the printout that it references LSSCM with respect to Tequila Smith. I'm pleased to advise the court that working with Ms. Bauer, that we've come to a resolution that will resolve this case in total in the form of a conditional dismissal. Ms. Bauer has talked to Tequila Smith about this, and I understand that we're all in agreement. The conditional dismissal, if I can go through the terms real quick.
Yes, sir.
Rent is $1,392.32. That pays rent through August 2nd. We have a conditional order of dismissal. Ms. Bauer has a copy there, and she has my permission to sign it and present it to the court, or I can sign her name or Tequila Smith's name and email it to the court. The judgment is set aside that currently exists. The defendant will pay the $1,392.38 by 10/15/25. The defendant waives all defenses, including notice. The defendant waives the 56-day rule. The plaintiff agrees to accept third-party funding. No late fees will be assessed from July of 2025 through October of 2025 while she's getting her assistance. Tequila Smith will be dismissed without prejudice, so the agreement will be as to all occupants. And if 4B is checked on the conditional order of dismissal, Tequila Smith will be emailed a copy of the judgment in writ if such is required. Separately from that, I understand my client is recertifying to remove the child support effective July 1. And no late fees, I think we already talked about, from now until October. That's our agreement.
Is that a correct statement?
Yes.
Smith of the agreement. Do you have any questions regarding that agreement?
No.
All right.
This has been signed by Ms. Smith.
Ms. Bauer, you can
And-
sign my name to that agreement if you like, and then the judge could, or somebody can.
Well, what I'll do, Mr. Hughes, with your permission, is it says that there's an S/ there. I'll just put my initials indicating your
Thank you.
acquiescence to that.
Thank you.
All right. And oh, hold on a second. Is this attachment to go with this,
Yes, Your
the
Honor.
further order portion? Got it.
I just wasn't sure which order to put those in, but maybe it should.
No, that's fine.
It's referenced
Oh,
as
Your
an
Honor, if
attachment
Miss-
on number
If
3.
Miss Smith could get a copy of that before she leaves, she needs it for something early Monday.
here. You don't have any questions regarding this, Ms. Smith?
No,
All right. And you're comfortable with everything that's in it? Okay. I do have to advise you have 3 business days to think about it. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court within those 3 business days. Doesn't mean I'd set it aside, but you have that opportunity to do that. You understand that?
yes, thank you.
All right, fantastic. I will indicate this is conditionally dismissed. We'll get your copy.
Thank you.
You take care, Miss.
Judge, will I be mailed a copy too? I don't have,
Yes, we will do that, sir.
thank you, Judge. Have a good weekend.
You do the same, Mr. Green.
Thank you, Ms. Bauer.
Arbor Meadows versus Karen Contreras Hernandez.
Good morning, Your Honor, or good afternoon, Your Honor. I apologize. Michael
Way I'm
Burns.
going it, yeah, you guys can switch it. Way I'm going, it's gonna turn into morning, but
I hope
anyway,
not.
go ahead.
Michael Burns, P 87855 on behalf of plaintiff, Your Honor.
Your name
Karen Contreras Hernandez.
and what are we doing on this?
Your Honor, this was a termination of tenancy based on violation of community guidelines. Ms.
Yes.
Contreras Hernandez has brought the property into complete compliance. So we're happy to
We
report
just
that it,
needed to wait for her to get from overseas to do that.
yes, Your Honor.
Because somebody thought I was gonna kick out somebody in the military. It wasn't gonna happen.
Correct.
Welcome back.
Thank you.
And so I have a dismissal.
Yes, Your Honor.
We're gonna be done with this.
Yes, Your Honor.
You have any objection to that?
No, I do not.
Case is dismissed. That is without prejudice. All right. Thank you very much, ma'am. And again, as I think I indicated to you before, thank you for your service, you and your family.
Thank you.
All right. And it's a pleasure actually seeing you and not on Zoom
Right.
in some faraway location. But I will tell you, as I always say, I get to do what I get to do because of people like you. I appreciate it.
Thank you, sir.
Court calls the case of Bele Properties versus Melissa Daly.
Good afternoon, Your Honor. Michael Burns, P 87855 on behalf of plaintiff. Bar numbers. Yeah.
I guess it's going to be Melissa Daly, Carla Hardman, Cindy Hart.
Judge Dominic Camden appearing on behalf of the defendant, Mrs. Daly, who's present, sitting to my right.
Okay, hello.
The complaint, counter complaint filed in this case, Judge, we've spoken to each other in the hall and have been unable to reach a resolution in this case.
Oh.
So I do have a procedural question. The complaint to evict is a summary proceeding, but the counter complaint is not. Counter complaint is related to a breach of habitability, as well as breach of the requirement, quiet enjoyment, and then basically a wrongful eviction, which I think entitles me to a certain degree of discovery. And so the question that I have is, you've got a summary proceeding, but you've also got a,
You're only allowed discovery in district court if I allow it, but
and that's where I'm going.
yeah.
So I'm looking for some form of discovery on this case.
What is it you're specifically looking for?
Well, the property was left in a significant degree of disrepair, and I think counsel is going to indicate, I'm not trying to advocate for him, but I think he's going to indicate that my client caused it. My response is going to be that it was not caused by my client, that it was basically left in significant disrepair by the landlord. There's also some communication that's been going back and forth from Section 8 with regard to their failure to keep the property in a habitable condition so as to allow my client to enjoy Section 8 and to allow that funding. And so I'm going to want some discovery there as to communication back and forth between Section 8 and the plaintiff.
Response, Your Honor? I don't think I'd necessarily object to the discovery related to the counter complaint, but as it goes for our initial complaint, it involves an unauthorized occupants and unauthorized animals on the premises. It's a pretty straightforward case. We believe our proofs are more than sufficient. As it relates to brother counsel's counter complaint, I don't think we'd have an issue of that, but we'd like to keep our initial complaint on schedule and on track and hopefully have a resolution or a judgment in it as soon as possible.
So at least on the animal issue, Judge, there's a text message from October 18th of 2023, where they basically told my client she had to have her animal registered. My client responded back with, I told you about the dog before I moved in. She's my emotional support dog, and you were okay with it as long as I got a letter from the doctor. I emailed you the letter from my doctor on April 11th, and you texted me back saying it was okay. Their response was, that is correct. We apologize. We had forgotten about that. So this is not as simple as counsel seems to be indicating or would want it to be. The animal was approved by them, and I'm not exactly sure who the unauthorized occupant is.
And we are willing to put our proofs on the record as to who the unauthorized occupant is and the status of the animal not being authorized in the unit, Your Honor.
All right. So with reference to discovery, do you know specifically what you want?
I also want to, I'm probably going to be amending my counter complaint as well, Judge, because they had her vehicle towed off the lot. And so, but I'm going to be looking for communications between Section 8 as well as from the plaintiff, which probably could be obtained either from written discovery to the plaintiff or to a subpoena to Section 8 or both, one or the other. And then with regard to the repair, I'm going to want their maintenance records and their repair records.
Have you made the request?
He's not made any requests yet, Your Honor. And we are now.
That part is accurate, Judge. I will not contest that.
It's been almost 2 months in this case, Your Honor. We've had no discovery requests.
It's actually been longer than that. They've tried to evict my client 3 times.
All right. Well,
So
great. So the way I work with discovery, particularly district court, is make the request. I think counsel knows how I work. If the request is reasonable, you can just send a letter. If the request is reasonable, I expect people to comply, much like the disclosure, sort of an analysis of disclosure provisions. This is what I need. Get it to them and see where you are.
fair enough, Judge.
Okay. So how much time do you guys need to accomplish that? Yeah.
It's going to be going your way, so I'll defer to you on how long it's going to take. I can have the letter out next week.
Your Honor, I'd say no more than 60 days.
60?
Yes, Your Honor, for the full bench trial. If Your Honor wants to keep it shorter, I'm more than willing to. I know this has been going on for some time.
No. How much time do you guys need to get all your paperwork together? Because then I'm going to set a final settlement conference.
I'm deferring to you, counsel, because you're the one with the records, and I don't know what it's going to take on your end to get it. I can tell you, I can put the letter together next week. The question is going to be, how long is it going to take you to provide the records? And I'm trying to show you a degree of grace.
I understand.
Yeah,
That's
okay.
why I said 60 days is because I think that's more than enough time.
To do what?
To have everything all
Build a
laid
house
out.
in 60 days. Look.
Your Honor, and then I cut it down to 21 days. And I mean, I'm trying to work with both sides here and nobody's giving me anything.
Oh, Joy, you being so nice to each other. Listen, here's what we're going to do. You're going to get your communication out. I'm going to adjourn this hearing out to September. Do I have the 12th?
Yes, sir, you do.
All right. I'm going to adjourn this to September 12th, 2025 at what time?
2 p.m.
2 p.m. We'll see where we are with discovery, where we want to go. And likely from that date, I'll then set a final settlement conference. And if we need to After that, if we need to proceed to trial, we can. Yes, sir.
This is where the hearing evolves from a routine eviction dispute into a much more complex civil litigation matter. Up until this point, both sides have been debating facts, but Judge Simpson recognizes that neither party is yet equipped to fully prove its position. Instead of forcing an immediate decision, he shifts the case into the discovery phase, where documents, maintenance records, communications, and other evidence can be exchanged before anyone argues the merits at trial. That move protects both sides by ensuring the court bases its eventual ruling on evidence rather than competing allegations. Notice the judge also addresses an important procedural issue. Defense counsel wants maintenance records, Section 8 communications, and documentation relating to the property's condition. But the plaintiff correctly points out that no formal discovery requests have actually been made. That's a significant procedural weakness. Courts generally expect attorneys to first use the discovery tools available to them before asking a judge to intervene. Judge Simpson's response reflects that expectation. Make reasonable requests, attempt to resolve disputes cooperatively, and only seek court involvement if someone refuses to comply. There's another strategic layer here that viewers might miss. The plaintiff wants the eviction claim to move forward quickly because summary eviction proceedings are designed to resolve possession disputes efficiently. The defense, meanwhile, has raised counterclaims involving habitability, quiet enjoyment, and alleged wrongful eviction, issues that typically require a much deeper factual investigation. Those competing objectives create a procedural balancing act. The judge isn't choosing sides, he's managing the case, so neither party gains an unfair tactical advantage simply because the timeline favors one form of claim over another. Watch how Judge Simpson also manages the attorneys themselves. When neither side provides a practical time frame for completing discovery, he steps in and imposes structure on the process. That's an important judicial function. Effective case management keeps litigation moving while preventing unnecessary delays that increase costs for everyone involved.
I have trial on that date, Judge, on a case that I do believe is going to settle. So
Where?
I am in circuit court in front of Judge O'Brien.
Oh, she said she'd wait.
As long as I can make that representation that you said that to her, Judge, I have no problem.
no. Oh, no, that was never said.
That's
Don't
fine.
find-
I,
Okay, we'll
I am.
work around that. If it becomes an issue, then just let the court know. We'll figure it out.
All right, thank you.
All right, thanks, Gabe.
Thank you, Your Honor.
Westridge Mobile Home Park versus Jessica Holloway.
Good afternoon, Your Honor. Michael Burns, P 87855 on behalf of plaintiff.
Her name?
Billy Hubbard.
That's right. You're defendant too. You're always here, so.
Yeah.
All right. Okay, where are we on this case?
Your Honor, I submitted a dismissal to the court. The amount's been paid up. I've been informed by my client that we're all set. The only reason I'd asked to speak before the court was there is an amount in escrow that we just need released to my client. And I'm trying to find the most expeditious way to accomplish that. But otherwise, we've dismissed the matter.
So your indication that it's been paid includes the 1,230.
Yes, Your Honor, that
escrow.
Yeah, the account should be settled. We just need the amount released to my client.
And then you do have some other Investor Realty Group versus Bonner, Augusta Woods versus Ballard, Westridge Mobile Home Park versus Spencer. Those matters are dismissed on plaintiff's motion without prejudice. Ian Greenlee versus Michael Bele.
Right, Your Honor, I'm sorry, did you just say that Ballard was dismissed?
Hang on a second.
Yes, that is a dismissal.
There was a dismissal that was filed. Why, go, okay. You just folded your arms and went huff like you huffed, so.
Well,
there's
if I've been sitting here for I emailed them on Tuesday, giving them their manager's acknowledgement that the funds have been paid and asked for a dismissal. I didn't hear anything back. I called, I didn't hear anything back. And now I've been, look, I always enjoy watching your docket, but it's been 2.5 hours that I could have been more productive elsewhere.
Yeah, I was not aware
Yeah,
I
no,
don't
I'm
think
not
I
blaming the
saw it on
court.
my
I would have
screen.
expected a call from Mr. Levine's office or something.
Yeah, I can't, he's actually walked out of the courtroom. I don't know why.
All right.
We received the dismissal. It's stamped by our clerk's office yesterday, so
Oh,
I'm not
God.
sure why they didn't communicate that to you.
All right. Enjoy your weekend,
All right.
Your Honor. It's been nice.
All
watching
right, you too.
Be
Take
well.
care.
Bye-bye.
All right, Greenlee versus Bailey.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff. State your
Your
name.
name?
Michael Bailey.
Your Honor, I talked to Mr. Bailey. He is going to pay $400. We'd ask this matter be adjourned.
Okay.
He's going to pay $400 on the 28th, on the morning of the 29th. I should be able to verify that before we come back to court. And then I think we're going to do a payment plan. He's also got an application in with Hawk. If they pay it, great. If not, we're going to work out a payment plan.
Got it.
Just make sure you make the payment that morning, okay?
Yep.
What is the claimed amount?
The balance right now is $2,030.
Okay. So he's gonna pay the 400 no later than the 29th, and then got it. So I'll adjourn this to August 29th, 2025 at 12 noon.
So make sure you have that payment made by then.
Okay.
Okay? I'll see you then.
Thank you, sir. Mrs. Haverkamp, LLC versus Alexander Jackson.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Your name?
Alexander Jackson.
Okay,
Mr. Jackson just applied for SER yesterday, so I know technically it's late, but he also says he's going to pay $600 on the 28th, if I remember correctly.
Mhm.
And so his balance right now is $1,505. If he pays $600, that'll take him down to $905. And I told him when we come back on the 15th, on the 29th, that he needs to have a date, because we do not want to go into September and then have to include the September portion. And we've agreed that on the 29th, he'll have a date for me by which he'll pay the balance.
okay. Is that correct, sir?
Yeah, is that okay if that date's in September or no? Is it okay if that date's in September?
Oh, yeah, no, the payment date will be in September, but I don't want the court date to be in September,
Okay.
because then we'll have to deal with September's rent.
Yes, that's fine.
But yeah, no, I just need a specific date when you come back that day.
August 29th, 2025, 12 noon.
Judge, I work a double that day.
What?
Can I have Zoom court?
You want to do what?
Zoom court that day?
Why?
I work a double, and if you want me to miss work.
You want to work it, you work
I'm
a
getting-
double?
I'm getting overtime that day, and if you want me to miss overtime that day and come
What
here.
do you mean you? I am
Yeah.
not the reason people are here.
You're
It's,
right.
it's everything everybody else did. You guys were just brought here. So,
Can I make a suggestion? Do me a favor. After you make the payment on the 28th, call me
Okay.
and tell me the date by which you want the judgment to expire in September.
Okay.
And then you should send Ms. Weidling a note saying that you would like to appear by Zoom, and then we'll be able to put that on the record.
Yes.
whatever he's,
Okay.
I'm tired.
Do I get the form out here?
But call me ahead of time so that we have it already done.
Well, can we give him a copy because the clerk's office is closed at this point?
I apologize for interrupting, Your Honor.
No, it's okay.
Thank you.
He was doing that just to. So the 29th at noon.
29th at noon.
Yes.
All right, I actually might can show up for that one. Double starts a little later.
Oh, see, why you put me through all that? All right, fine. All right. Have a good weekend, young man. Sandy McFiddish, LLC versus Lindsay Love. Oh, he's back.
Is your phone number in the court?
My phone number is on the court paperwork, yes. Although I may change it between now and then.
Hello.
Hello, hi.
Your name?
Lindsay Love.
All right. Where are we on this case?
I have a consent judgment.
Oh.
The amount of rent that's owed is $2,615. Court cost of $175 for a total of $2,790. Ms. Love and I have agreed that that amount has to be paid by August 31st or she can be evicted, and I advised her of her rights under the court rule.
All right. Is all of that correct, ma'am?
That is correct.
Do you have any question regarding anything on the judgment?
No, Your Honor.
All right, fantastic. What I will do is I will sign it. You're all set.
Thank you so much. I'll see you then.
Thank you.
Have a great day.
Sandy McFiddish versus Alexander Donovan.
That case we dismissed.
Oh.
He paid his balance down to $20. I told him to pay with September's rent and I dismissed the case.
All right, that case is dismissed without prejudice on plaintiff's request. And 103 South Huron LLC versus Mario Mann.
David Fancher on behalf of the plaintiff. Your Honor, Mr. Mann was here.
Okay.
He had to go to work at 5 o'clock. So at about quarter of, I told him to go and I'd put it on the record. This is a motion to set aside a default. Mr. Mann represented to me that he has money in escrow with the court. So I guess I'd ask it.
Yes, we have 740.
So what we've agreed to do is to have the court release that to my client. And we're going to leave the judgment in place, but give him till September 12th to pay the remainder of the judgment. The judgment amount, I believe, is $25.99. So after the 740, that'll basically take it down to around 1,800. He says he's going to pay 1,000 on the 29th and 1,000 on, and then the balance of it on September 12th. I said that was fine. So if we
So
can,
what I will do is I will release the escrow to the plaintiff, and defendant then has until September 12th to pay the balance of the judgment.
yeah, do you need me to do anything?
No.
The court will release it without.
Yep. Oh, yeah, we'll release it because I wrote it. Sure.
All right.
All right.
Thank you. Have a great weekend.
You do the same.
What's left of it, right?
You're right. Westridge versus Tolbert. Get that one done.
Good afternoon, Your Honor. Michael Burns, P 87855 on behalf of plaintiff.
Your name, sir?
Jeremy Tolbert.
All right. What, you guys got a chance to talk? Where are we?
Your Honor, we did work out a rough framework of a resolution of the matter that I do think will be doable, but I don't have contact with my client because they're out of the office. So I can't, in good faith, put it on the record. So I would just ask for an adjournment. I believe we'll have it worked out before the next hearing, though.
All right. August 29th, 2025 at 12 noon. Okay.
Perfect, John. And I think that is all for me. So I appreciate it. Have a good weekend.
You may want to have your office. You walked out on the case. What was it? Ballard, the dismissal.
Yes.
Somebody may want to contact the legal clinic, Mr. Santa Croce. He was a little bit perturbed that the case was dismissed because the funds had been received, but nobody contacted his office to let him know of the dismissal. So he's been sitting on Zoom.
Oh, I apologize. I had spoken to Emily and I had let her know that I was submitting the dismissal. So I never caught her last name, but she was the point of contact I had with legal services. Her and I had been working. And
I think we're talking.
Yeah.
Different services.
They were represented, so you let somebody know.
Yeah.
So wrong. You let legal services know. It was University of Michigan Clinical Law.
And this was for Ballard for Investors Realty.
Who's on the other side of that?
No, this is Augusta Woods versus Ballard.
Augusta Woods versus Ballard.
They didn't even provide me that file, Your Honor. I have no contact with that. I apologize for misrepresenting.
Okay, so it may be somebody can just contact him. I tried to cool him off.
You're thinking of the Bonner case.
Thank you. I was getting them. Thank you.
It's okay. Sir, you're all set. Thank you. We'll see you in a couple of weeks. Court recalls case People versus Caleb P.
Attorney Carrie Zanon on behalf of
Jill Bauer on behalf of the
maintenance will have the key. We'll meet her at the unit. I was gonna say 6 o'clock. How long does it usually take you to get from here to there?
like about an hour.
Then I'll call back and I'll tell them 6:30.
Okay. All right, so somebody's gonna meet her with the key. Anything else I need to do on this?
Not for me, Judge.
No, I don't think so.
All right, so with reference to the motion to show cause, I'm gonna deny the motion. I'm gonna deny any request for sanctions and or costs. And the key will be available
It's gonna get.
by 6:30.
6:30. Yes, Judge.
No, Ms. Key, what I'm understanding is maintenance is gonna meet you at the unit at 6:30 to get your key.
I thought she called me.
Oh,
What did she tell you?
She said that she was gonna have it left in the mailbox. She did say somebody was gonna meet
Yeah.
her, but she said that was happening to their personal time, so. it was Left in the mailbox.
Okay, I'll reach out to them before I leave as well.
okay, thank
All
you.
right.
Well, he-
Thank you.
Judge Simpson's final ruling highlights an important distinction that many people outside the legal system often overlook. A party can fail to meet the exact terms of a court order without automatically deserving sanctions. Throughout this hearing, the judge carefully separated poor communication from intentional misconduct. The landlord clearly failed to keep the tenant and opposing counsel informed when the original rehousing deadline slipped, and Judge Simpson openly criticized that lack of proactive communication earlier in the hearing. However, by the time the court reached its decision, the evidence showed that the apartment was nearly complete. The lease paperwork had been signed, the keys had been prepared, and a specific plan was in place for the tenant to receive possession that evening. From the court's perspective, the underlying objective of the consent order, getting the tenant into safe housing, was finally being accomplished. This also demonstrates an important principle of judicial discretion. Courts generally reserve sanctions for situations involving willful noncompliance, bad faith, or conduct that substantially undermines the authority of the court. Here, Judge Simpson apparently concluded that although the landlord's handling of the situation created unnecessary stress and inconvenience, it did not rise to the level requiring financial penalties or contempt-related sanctions. Instead, he focused on ensuring the practical problem was resolved immediately while placing the final arrangements clearly on the record so there would be no further confusion. The broader lesson extends beyond this individual dispute. Consent orders are binding court orders, and if circumstances change, communication is often just as important as compliance itself. A simple request for an extension or timely notice to opposing counsel can prevent weeks of uncertainty and unnecessary litigation. Likewise, tenants should continue documenting delays, conversations, and promises because that record becomes invaluable if the dispute later escalates. What do you think? Should the landlord have been sanctioned for missing the agreed timeline, or did Judge Simpson strike the right balance by prioritizing a practical solution over punishment? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.